When they served with the grounds of detention, they gave Malaz all this along with the pen drive, which excluded these 4 videos.
Which was the one which was given in October?
Laptop.
Laptop.
To view the videos, Malaz. But they didn't have these 4. That was given on the 5th of October. Which is why I started writing to them.
And this was given on 5th, is it?
This was given on
29th.
29th itself, Malaz.
What was given on 5th?
The laptop.
Laptop.
But otherwise I can't see.
All right.
Even if I have
Other than the laptop, what else was given on?
all the other material. All
No, on 4th.
on the 5th. On the 5th, Malaz, the pen drive had everything other than these 4.
Yes, for 29.
On 29th, Malaz, they gave me this. They gave me a pen drive. On 5th October, they gave me a laptop so that I can see it. But that pen drive did not have these 4 videos.
Pen drive furnished to you on 29/9/2025.
Yes,
Did not contain these 4 videos.
that's correct. So that even if they gave the laptop to me on the 5th of October, it really didn't matter.
All right.
Now, Malaz, then I started writing letters to them. Finally come to 205, annexure 8, Malaz. Yes. Malaz, I wrote first time on the 7th of October. I don't have a copy of that letter, but they can produce it, Malaz. I wrote on the 7th of October. And then at 205, Gitanjali, that is his wife.
You are referring to 205.
Yes, that's the typed copy.
1610.
Yes. In my meeting with Sonam Wangchuk today, he informed me that since the dates of the detention were given to him and the pen drive with videos were shown to him, he has requested through several written letters about 4 missing videos. Till date, they have not been given to him. In between, he wrote on the 7th of October, which letter is with them, Malaz, so that can be asked for. So she is saying that, look, I spoke to him because Your Lordship allowed her to meet him, if Your Lordship will remember. So she spoke to him and she is saying that he has told me that these 4 videos are missing, though the pen drive is there. I requested you to give me a copies of Wangchuk's letters where he has pointed out the missing videos and requested for the same. So she asked, please give me those letters. I was told that I will be given copies of his letters. I wanted for 1 hour for the same. I waited for 1 hour for the same after 1 to 2 meeting and missed my flight at 3 for the same, but I was not provided. Kindly arrange to send me email Gitanjali so and so copies of letters to you to provide him the missing videos several times. So clearly, Malaz, case made out. Right? So that's her letter. Then annexure P12, page 298. Wangchuk's a letter, Malaz, of 21st of October.
Page
298. So all this is part of the petition not replied to. I've shown to Your Lordships all the paragraphs as far as the replies are concerned. I wish to express my gratitude for your patience. My Lord has it, Justice Bharali?
Yes, yes. Letter to Chairperson Advisory Board.
That's correct. I wish to express my gratitude for your patience with my submissions of the written representation. For the last 2 days with my draft ready, I have been waiting for. It should not be some, sir, but it should be some advice from my legal counsel and my wife Gitanjali on the draft notes that I was able to share with them on 16th October only, following the permission given in the SCI hearing. The 4 videos mentioned in annexure of the grounds of detention, of which only the screenshots were supplied. I showed to Your Lordship that. And unlike all other videos, no digital videos of these were in the pen drive supplied by detaining authorities on 29 September. Since these videos looked very important in justification of my detention, I made repeated appeals for them. However, since neither A nor B has been received by me till 5 p.m. today, this is 21st October, I have finally decided to send to your kind self a draft version of my representation without further delay, because we had to file the representation. And with apologies, in case I get any input from any of the above sources, I shall prepare a final version and send to the audience. So this is written on the 21st. Then advisory boards, Malaz, page 294, Malaz, in Annexure 11, replies to this.
Replies 294, earlier.
294, over the page 295 minutes is the order of the advisory. In his representation received by this board on 2210, that letter is 21, by email, the detaining has stated that the videos reflected in Election A have not been provided to him. In view of his assertion of the detenue, these videos shall be made available to him today itself. A copy of this order shall be sent. So then the videos were supplied. 294 over the page is the order. The order says, in his representation, my lord has it. In the meantime, the wife had also been asking that you give me, at least give me those documents. Those were never given. So the point is this now. If the documents, that's the proposition of law, relied upon in the grounds of detention are not supplied, the order is vitiated. That's the proposition, which has been upheld by this court in several judgments. I start giving you, lordships, those judgments. The other side. Give it.
Yes.
Well, the first judgment is 1981, 1 SCC, page 419. You just hand it over to your lordship. I'll put it in a compilation notes later.
Yes.
Justice Fazal Ali and Justice Kaushal. The petitioner has put forward several grounds of attack against his detentions. Like me, Millers, I have several grounds of attack, which was directed by an order dated so and so, passed by the Deputy Secretary, Home Department, under Section 3 of Coffee Posa. Petitioner claims to have been arrested on 5th May, although according to the Counsel for the State, the date of his arrest is 13th May. In the view that we take in this case, the question as to when the petitioner was arrested is not relevant. The grounds of detention were admittedly served on the petitioner on May 13. A day and a prayer for making available the copies of the documents forming the material on which the order of detention was based was made by the detainee on August 21, 1980. That prayer was, however, refused on September 12, 1980, when the petitioner was informed that the copies of the relevant documents could not be supplied. In our opinion, this is a case clearly concluded by two recent division bench decisions of this court. Let's quote those. In both these cases, this court has taken the view that on a proper construction of 22.5, the service of the grounds of detention on the detenue can be complete only if they are accompanied by the documents or materials on which the order of detention is based. For then alone will the detenue be able to make an effective representation. In other words, if the documents which form the basis of the order of detention are not served on the detenue, along with the grounds of detention, in the eye of law, there will be no service of the grounds of detention, and that circumstance would vitiate his detention and make it void ab initio. That's okay. This view has been followed throughout, but it's still there. The second judgment is Ahmed Kutti versus Union of India. This is a case where a bail application was not supplied, just that one document. And you will find reference to that at page 12, paragraph 19 of the judgment.
Paragraph?
19, page 12. May I read, Millers?
Yes, please.
I'll just wait for justice for a while.
Era 19.
Para.
Yes, please.
The next submission is that of non-supply of the bail application and the bail order. This court, as was observed in Mangalbhai Motiram Patel, has forged certain procedural safeguards for citizens under preventive detention. The constitutional imperatives in 22.5 are twofold. The detaining authority must soon as may be, as soon as practicable, after the detention, communicate to the detainee the grounds on which the order of detention has been made. And two, the detaining authority must afford the detainee the earliest opportunity of making the representation against the order of detention. The right is to make an effective representation. And when some documents are referred to or relied on in the grounds of detention, without copies of such documents, the grounds of detention would not be complete. The detainee has therefore the right to be furnished with the grounds of detention along with the documents so referred to or relied on. If there is failure or even delay in furnishing those documents, it would amount to denial of the right to make an effective representation. They ultimately say, but you know, when you asked the advisory board, they gave you the grounds. So you therefore made your representation. This settles the law, saying even if there is delay, it really doesn't matter, because it has to be within the 5 and 10 day period, which is set out under law under Section 8 and therefore would be a violation of 22(5). Next paragraph. It is immaterial whether the detainee already knew about their contents or not. So that's also there. In Mehrunisa and state of Maharashtra, it was held that the fact that the detainee was aware of the contents of the document is not documents not furnished was immaterial, and non-furnishing of the copy of the seizure list was held to be fatal. To appreciate this point, one has to bear in mind that the detainee is in jail and has no access to his own documents. In Muhammad Nazir Zakir versus so-and-so, it was reiterated that it being a constitutional imperative for the detaining authority to give the documents relied on and referred to in the order of detention pari passu the grounds of detention, those should be furnished at the earliest so that the detainee could make an effective representation immediately instead of waiting for the documents to be supplied with. The question of demanding the documents is wholly irrelevant, and the infirmity in that regard was violative of constitutional safeguards enshrined in 22(5). So I don't have to demand the documents. What they should have said is, these are the links, this is the pen drive, you can have access to those links, this is the laptop, blindly therefore file your representation. They did none of that. That's what this law says. I don't have to ask. It's their constitutional duty to supply and indicate to me that this is how you can access these documents. You can't say there's a link there so you can get the documents. It is also imperative that the detainee was already in jail. The grounds that if the detainee was already in jail, the grounds of detention are to show the awareness of that fact on the part of the detaining authority. Otherwise, there'd be no application of mine. So leave that out. Now kindly come, Mullahs, to at the bottom of Khudiram Das Muller's paragraph 22 at the bottom, famous decision. This court held that where the liberty of the subject is involved, it is the bounden duty of the court to satisfy itself that all the safeguards provided by the law have been scrupulously observed and that the subject is not deprived of his personal liberty otherwise than in accordance with law. The constitutional requirement of 22(5) is that all the basic facts and particulars which influence the detaining authority in arriving at the requisite satisfaction leading to making the detention order must be communicated to the detainee so that the detainee may have an opportunity of making an effective representation against the said order of detention. It is therefore not only the right of the court, but also its duty as well to examine what are the basic facts and materials, because we're on a habeas corpus, challenging the detention order, which actually, in fact, weighed with the detaining authority in reaching the requisite satisfaction. The judicial scrutiny cannot be foreclosed by a mere statement of the detaining authority that it has taken into account only certain basic facts and materials, and though these facts may have been known to the authority concerned. That, of course, is there because they are the ones who are relying upon this. So the infraction is not that they didn't have these documents, that they didn't supply them to me. So your lordships may leave this part and kindly come to paragraph 25. In the middle of the paragraph, you'll find on the middle of the paragraph, if the detaining authority considered that order. Your lordship see that? My Lord Justice Virali has that. This is in the middle of paragraph 25. Just in the middle almost, Mullahs. If the detaining authority considered that order,
one could not state with
and one could not state with definiteness which was his subjective satisfaction, would have reacted and it could have persuaded the detaining authority to desist from passing the order of detention. If in the instant case the bail order on condition of the detainee's reporting to the customs authorities was not considered, the detention order itself would have been effective. Therefore, it cannot be held that while passing the detention order, the bail order was not relied on by the detaining authority. So the detaining authority relied upon these 4 tapes. So they had to be given to me. It was reiterated in these 2 cases that if the documents which form the basis of the order of detention were not served on the detainee along with the grounds of detention, in the eye of law, there would be no service of the grounds of detention. And that circumstance would vitiate his detention and make it void ab initio. That is reiterated in paragraph 27. Your lordship may just note that it says the same thing. So that is this judgment of Ahmed Kutti. Then Sarabjit Singh Mokha, another judgment, 2021, Supreme Court. three honorable judges. The relevant paragraph is para 20 onwards. Saying that, sorry.
One more copy. Wait.
Oh, what?
We can give you.
Oh, leave it. We can't waste time over
Yeah,
that.
yeah. Or I can read it.
No.
Yeah,
It's all right. This is good enough.
Okay.
Well, you are having only one copy.
One copy.
No. That's not possible.
No,
Don't give my copy, please.
they can use yours.
Just
You
give
can
me, give
this.
the, I'll use this other. You also may remove the flags there, but I'm sorry for that.
No.
Page 121, Mullahs, paragraph 24.
20?
Para 24 at page 121 of the judgment. Sorry. Okay. Kindly come, to 120, page 120, Mullahs. Para 22, we'll read from them.
22.
Lordship has that, my Lord
Yes,
Justice
yes.
Arvind Kumar has it. Article 22(5) of the Constitution mandates that the authority making the order shall, as soon as may be, communicate the grounds on which the order has been made to the person detained. And 2, the detaining authority shall afford to the person detained the earliest opportunity of making a representation against the order. Clause 5 of 22 incorporates a dual requirement. First, of requiring the detaining authority to communicate the grounds of detention as soon as may be. And second, of affording to the detainee an earliest opportunity of making a representation. Both these procedural requirements are mutually reinforcing. The communication as soon as may be of the grounds of detention is intended to inform the detainee on the basis of which the order of detention has been made. The expression as soon as may be imports a requirement of immediacy. But the point that really the underlying constitutional issue is the following. Why is the 5 and 10 day limit given? It's given because at the earliest possible time, you should get all the documents. Why? Because the advisory board is to meet much later. So you should have enough time to be able to logically look at the documents, analyze the documents, and then decide as to what kind of representation you wish to give. So there has to be a time lag between the supply of the documents and the sitting of the advisory board, which means that the detainee has a constitutional right to be given that space of time so that he can make an effective representation. If you tell him that, all right, we'll supply you the document one day before the advisory board, you actually are violating the very law, because the concept is that I must have enough time. That's the constitutional premise, Mullahs, on the basis of which, Mullahs, these judgments have been pronounced.
So how do you fix the outer limit?
That's Parliament.
No, the law says 5 days,
No, maximum of 10.
maximum of 10 days.
Yes.
So even 9th day it can be given,
Yes.
or first day it can.
No, but I'm talking about the advisory board. Your Lordship is right. Means earliest is
The
5,
maximum is
but
the
not
10th,
later than 10.
not beyond 10th day.
Correct. Now the advisory board meets in a month. So you've got within 10 days, you have the ground. You have 20 days. That's the point I'm making. You have 20 days to consider the recommendation.
So the detainee gets the breathing time.
Yeah.
The detainee gets the breathing time.
Correct. As it is in jail, he's not breathing, but he gets some breathing time, but it's for the representation. In a lighter way, but it's
No, it's not.
so he gets some. That's the purpose, Mullahs. Why would the Parliament fix Mullahs 5 to 10 days only for that? So it gets that time, that space. Otherwise, you can say you can give it on the just before the advisory board meets, they'll say it is a violation of 22(5). Why? Because 22(5) uses the expression as soon as may be. As soon as may be is interpreted by Parliament as maximum of 10.
Oh.
So if you violate that timeline, then naturally, Mullahs, the 22(5) is violated, which is a fundamental right. That's the logic, as I understand. Clause 5 of 22 incorporates a dual requirement. First, of requiring the detaining authority to communicate the grounds of detention as soon as may be. Second, of affording to the detainee the earliest opportunity of making a representation. Both these procedural requirements are mutually reinforcing. The communication as soon as may be on grounds of detention is intended to inform the detainee on the basis of which the order of detention is made. The expression as soon as may be imports a requirement of immediacy. The communication of the grounds is in aid of facilitating the right of the detainee to submit a representation against the order of detention. In the absence of the grounds being communicated, the detainee would be left in the dark in regard to the reasons which have led to the order of detention. The importance which the constitutional provision ascribes to the communication of the grounds as well as the affording of an opportunity to make a representation is evident from the use of the expression as soon as may be in the first part in relation to communicating the grounds of detention and allowing the detainee the earliest opportunity of availing the right to submit a representation under 22.5. 22.5 reflects a keen awareness of the framers of the Constitution that preventive detention leads to the detention of a person without trial, and hence it incorporates procedural safeguards which mandate an immediacy in terms of time. The significance of 22 is in that the representation which has been submitted by the detainee must be disposed of at an early date, the communication of the grounds of detention as soon as may be, and the affording of the earliest opportunity to submit the representation against the order of detention will have no constitutional significance unless the detaining authority deals with the representation and communicates its decision with expedition. Then they quote 22.5. Then the provisions of NSA subscribe to the mandate of 22.5. Section 3.4 contains a requirement that once an order of detention has been made, the officer making the order must forthwith report the fact to the state government, together with the grounds on which the order has been made and other particulars which have a bearing on the matter. No such order should remain in force for more than 12 days, unless it has been approved by the state government. In the meantime, this period is subject to the proviso which stipulates that where the grounds of detention are communicated by the officer after 5 days under Section 8, but not later than 10 days from the date of detention, subsection 4 will apply as if the word 15 days stands substituted for 12 days. Upon the state government either making or approving the order under Section 3, it is under a mandate under 3.5 to report the fact to the central government within 7 days, together with the grounds on which the order has been made and other necessary particulars. Then they quote Section 8. And then, Mullahs, had noticed earlier, Article 22.5 of the Constitution provides for the communication of the grounds on which the order of detention has been made by the detaining authority as soon as may be. 8.1 uses the expression as soon as may be, qualifying it with the requirement that the communication of grounds should ordinarily be not later than 5 days, and in exceptional circumstances for reasons to be recorded in writing not later than 10 days from the date of detention. 8.1 also embodies the second requirement of 22.5 of affording to the detainee the earliest opportunity of making a representation against the order to the appropriate government. Then, Mullahs, kindly, that's really it on this judgment. So, Mullahs, that's really the law on the subject. So the facts are established. The law is clear, Mullahs. And my request to your lordships is, if your lordships are inclined to look into this and decide the matter, then I need not go into the other facts. Let's
cover everything so that suppose we accept it, we may not go into other aspects.
But if the facts in this are clear to us, Mullahs, then
Let it not be in piecemeal, Mr.
All right.
So that we can once and for, so that you close it.
All right.
Suppose we accept the first point, we will not go into other points at all.
Okay. Well, the thing is that will take a lot of time.
No. Take your time.
Will be benefited by your argument.
No.
Getting some
very kind of you.
additional facets like that.
This is
We may also learn something.
this dialogue is a learning process on both sides. I've always said that, Mullahs. And unless your lordships, Mullahs, put questions to us, that learning will stop.
My senior used to say, any judge or a lawyer, if he says he knows the law, that is his last day.
Yes, I agree with you. I agree with it. I agree, Mullahs. I have to share with you an incident. I was a young man, 24. And the first case I argued in this court was in Court 2. The bench was Justice Palikar, Justice Bhagwati, and Justice Sarkaria. They didn't know me, who I was. And it's an election appeal. I won't go into the details. So Justice Bhagwati said to me, Mr. Sibal, or Mr. Young Man, he said, I've just rendered a judgment 3 months ago on this very point, which is the legal issue. So why should we hear this appeal where your judgment is covered? So I had the temerity to tell him that the judgment was incorrect. He accepted it, finally, and said it is the duty of the judge that where he goes wrong, he must accept that he was wrong. Look at the greatness of those times. We don't see them today because there's no dialogue.
On both sides.
I agree. There's no dialogue. There's no dialogue. There used to be a very, very constructive dialogue because you're laying the law for the rest of India and for times to come. It is not this case. It is the constitutional development of processes of law relating to liberty which will determine the strength of our democracy. That's what is necessary.
The law takes its shape and color depending upon the terrain it travels.